Good morning. Happy Friday. In his video, which just, I'll be clear, I haven't watched, people have reported on it to me, Chille made a big deal about, he called it South Carolina versus Edwards, 1963. It's actually Edwards versus South Carolina. It's a 1963 Supreme Court case. And he held it out as essentially saying that as long as he wasn't causing any danger, as long as he was no danger, that he could essentially do whatever he wanted, as long as he said that he's not causing any danger and he's exercising his First Amendment. That is not what Edwards versus South Carolina stood for. In Edwards versus South Carolina, there was a breach of the peace statute that was in question. The facts of Edwards versus South Carolina is there was a protest. There was a group of people protesting for civil rights in South Carolina near some sort of a government building. The police came and wanted them to move along. They refused, and when they refused, they started singing songs and giving speeches and things like that. So purely First Amendment protected kinds of activities. And they were arrested for violating this breach of the peace statute. Now, the South Carolina Supreme Court interpreted that statute to be incapable of specific kinds of descriptions, but a very general description was available to it. And the South Carolina Supreme Court upheld the convictions of these protesters. And the Supreme Court looked at it and said, hey, you know what? Picketing and protesting, these are, especially against the government, is a core First Amendment activity. So you can't criminalize it under this kind of generalized. You normally see a statute like this attacked under void for vagueness, but it's a state statute, and the state Supreme Court had already interpreted it in a way that made it so that the Supreme Court of the United States didn't want to say that it was void for vagueness, or maybe the void for vagueness doctrine hadn't really been established then, or something. I don't know exactly, but the Supreme Court didn't want to invalidate the law, and so they invalidated the conviction. It was pure First Amendment activity, but there was a caveat, and the caveat was the United States Supreme Court said if it was a different law, if it was a specific law, like a traffic law, that these people were accused of violating, then it would be a completely different analysis, i.e., it would probably not be a violation of their First Amendment right. Probably, obviously this is somewhat speculative, but it would probably not be a violation of their First Amendment right, and the state would likely be able to enforce those traffic rules, traffic laws. And in the footnote, I believe it was footnote 11, the United States Supreme Court puts forward one or two of these South Carolina traffic laws or city ordinances or whatever they were that may have been applicable, yet the protesters weren't charged under it. So the Supreme Court is basically saying, like, look, if they were charged under these, this analysis wouldn't be this analysis. They would probably, it is more likely that the state would be able to enforce a traffic law against a protester because it's content neutral. It's an activity. It's not speech related. It's action related. It's like burning the draft card. The state has a compelling interest in regulating the activities on the streets because, traffic is a necessary thing for modern society. I don't want to drone on and on, but I did check the way that Edwards versus South Carolina has been treated subsequent, because it is a 1963 case, and never once has the Supreme Court or any federal court, I didn't check state courts, I don't know, don't care, but never once has any federal court or the Supreme Court held that Edwards versus South Carolina stands for the proposition that as long as you're nonviolent, you can't be arrested for engaging in First Amendment protected activities. Excuse me, you can't be arrested while engaging in First Amendment protected activities. The fact that you are speaking does not give you license to violate other laws. The fact that you are engaged in First Amendment protected activities does not give you license to trespass, to obstruct the officers, to resist arrest, to give false ID, to do any of these other things. The First Amendment protected activity is protected. But the other things that you're doing while engaged in that First Amendment protected activity are not. And you can, in theory, be held accountable for those actions. And that's a distinction that a lot of times people like Chille are unwilling or unable to draw. Thanks for watching. Have a great day.